great. Hello, everybody. If you're just joining us, then you are very, very welcome. Great to see you. How are you? Michael, Lucinda, Philippe, how are you doing? Bobby, Dagmar, great to have you join us today. Oliver, how are you? So here we are. We are back to our legal program. I was just saying to Gordon, it seems like ages since we've done a session, actually, whereas in fact, we were doing them like every week during the height of COVID and every day at some point. But this is the first of two legal updates. And again, as always, thank you so much to Gordon for heading these up. We've got 50 people signed up today, but you know, as you all know, hi Jennifer. As you all know, we record these, and so it will be put up on YouTube. I'll send you the link to it tomorrow. So if you do have to step away, you won't miss out. Just a couple of wee things that I always say. First of all, it would be so much nicer to be doing this in a conference room in a 5-star hotel, and I very much hope that within the next month, we will be able to do that. We're all so excited about Seville. Everything's printed, everything's shipped. So we are very much looking forward to it. One of the reasons why we're doing this online and we'll be following up after Seville is that due to the multiple date changes that we've had to make over the conference, unfortunately, Gordon can't be there in May, so we're going to do these as online sessions instead. But as you know, if you don't know, you can always reach out to Gordon through our LinkedIn group or directly through me or through Gordon's email address, gordon@EuRA-relocation.com, if you have specific questions. A couple of bits of housekeeping. If you have a question at any time, please put it in the chat box. If you'd like the question to be seen by everybody, just remember to click down on the little arrow where it says host and panelists and switch that to everyone. Otherwise, Zoom just sends it to me and to Gordon. And I'm going to hand over to Gordon, and he will manage the PowerPoint. So when the PowerPoint gets switched on, you will see your screen suddenly go huge, which is quite annoying in Zoom. And all you have to do is press escape, and it'll bring it back down to its correct size. There's still quite a few more people to come in, but I think we'll get going. If you're okay, Gordon, I will. Yeah,
fire ahead, and I will attempt to share my screen.
Cool, I'll make you the host. Here you go. So like I say, again, if you want to put a question in at any time, just pop it in the chat box. I'll keep an eye on that. Gordon, you tell me if you want a question. If I see something come up that's very pertinent to what you're talking about at the time, we will interrupt and have a question that way. You can also use the Q&A, which is at the bottom, but if you prefer to use the chat, it is the easiest way to do it. So Gordon, I will mute myself, and over to you.
And Dom, just before you mute yourself, can I just check you are seeing the first slide, the introductory slide?
Perfect. Thank you very much.
The technology is functioning. Okay, hello everyone, and yeah, as Dom says, sadly the reason we're doing this online is that I'm unable to be in Seville, so hopefully we'll see many of you sometime in the future at a future event, but not sadly in Seville. Okay, let me just introduce this by thinking about why GDPR matters to relocation businesses. Why does somebody like me continue going on about the importance of GDPR? And the key factor is that our services as relocation businesses rely on personal data. And that can be as simple as basic contact information on individuals and on families. But in some cases, it can be financial information, it can even be medical data, maybe even in the context of home search, we may be collecting information on religious affiliations, etc. So it can be very basic information, or it can be wide, but either way, it's personal data, and that's what the GDPR covers. It's looking at how we as businesses protect the personal data of individuals. And I think the second really important reason is that wherever you are in the service chain, whether you are a corporate client, whether you are an RMC, a DSP, or another supplier in that chain, the ultimate client requires strict compliance with the GDPR. And in the event that we fail to comply with the GDPR, we face penalties, contractual liabilities to our clients, and legal penalties to the Data Protection Authority, depending on which country we're operating in. And it's also worth mentioning that the GDPR is important because it also applies outside Europe. So it's not a case of being able to say, well, I'm an Indian company or I'm an American organization, and therefore it's only Europeans that need to worry about this. If you provide or offer services in Europe, then the legislation extends to you. So that's something that's really important. It's not just EU registered companies or UK registered companies that we're talking about here. Okay, that's why it's important. Let's drill into what it's all about. I mean, there are hundreds of pages of GDPR legislation and annexes and etc. But for me, in trying to understand it and think how does it apply to a business, there are the 6 GDPR principles, and provided you really get a grip on what these principles are and what they mean for your business, then it actually provides the answers to most questions. And so let me run through fairly quickly the 6 principles. So the first one is called lawfulness, fairness, and transparency. What that means is that there has to be a legal basis on which an organization can handle personal data. So for example, you enter a contract with somebody as a requirement to deliver these services, you need to hold some data. I mean, as simple as a delivery of a product, there has to be a name and address, etc. So at its most basic, there's contractual lawfulness, but then there are other things such as you may have to hold data because you will have to make reports to a tax authority. So there's a legal basis for it. You may have a specific consent form that you ask an individual and their family members to sign, allowing you to hold their data, allowing you to transfer their data to another country. So what you need to think about, what is the lawful basis? Are we clear about that for holding and processing that data? And fairness and transparency. Fairness really means that you can't hide behind small print. You know, in the old days, lawyers were great at coming up with the small print on the, page 50. That kind of thing doesn't wash with the GDPR. You have to be very clear about what is happening, how you're handling data for an individual, and that leads into transparency. And we call the individual is called the data subject in the GDPR legal language. So the data subject always has to have complete clarity about what is going to happen with my data, where is it held, and what can I do if I want to complain about it or I want to change the data that's held. All of that has to be absolutely clear. Purpose limitation, the second principle, is saying that if I hold your data for one purpose, such as to provide you with relocation services, I can't then use that data for something completely different. I can't put you into a marketing database and start selling you something completely different unless I have your specific consent for that purpose. So it's single purpose. Third principle, data minimization, means that you can only hold on to that data for as long as it's actually required for the service you're delivering. Now, that can be as simple as, let's say it's a one-day orientation service in Dublin. Now, I will have names and contact details for the family. I probably don't need to hold that data beyond, let's say, a year or maybe 2 years maximum. Whereas if I've got financial information on, say, relocation expenses for that family, I may have to hold on to that data for, let's say, 7 years, because I will be responsible perhaps for reporting to a tax authority on it. So that's why there can be such a variation. Depending on the categories of data that you hold, you need to be clear, and you should have a policy that actually states, we delete this category of data in, let's say, 2 years, this category in 5 years, this category in 7 years, etc. Fourth principle, accuracy. If you are contacted by an individual and they say, you have out-of-date information on me, or you've got incorrect information on me, you are under a legal obligation to rectify the records. It's really as simple as that. The storage limitation, let me go back to the minimization. So I mentioned only keeping it for certain periods. This links into storage limitation and minimization, meaning that also I shouldn't ask for information that's not going to be required. So let's say I'm offering, again, an orientation service. I may send out a form to you to have your basic information, what you're looking for. But if on that form it says, please put in your bank details, then I would be holding that data illegally, because it's not necessary for the service that I'm offering you to hold that category of information about you. So very important, minimizing the data and then minimizing the period for which you hold that data. The last principle is called integrity and confidentiality. Simply means you have to have systems in place to hold data securely. You are under a duty of confidentiality to the individuals whose data you hold, and it's important that you have systems in place to do that. And in a moment, I'll talk a little bit about what that really means in practice. What kind of data security systems should a relocation business have? And then this is all pulled together by what they call accountability. And that really means that as a business, you have a responsibility to actually demonstrate that you comply with the 6 principles. So you have record keeping that shows when an individual, let's say, required an update of their data or required their data to be deleted, and you could show that you complied with that. So record keeping is important. Okay, now let me just touch on an issue that does cause problems in practice in the relocation world. It shouldn't really, because the concept of is my business a controller or is my business a processor? In principle, it's straightforward. It's in practice, in where you have supply chains, which can be quite complicated in our industry, that it becomes a bit trickier. So the controller is the business which determines the purpose and the way in which personal data is processed. So primary responsibility for complying with the law and being responsible to the individual whose data you're managing. The processor, by contrast, is processing the personal data on behalf of the controller. They have a similar legal obligation, but it's secondary to that of the controller. So the things that have to be put in place that I'll come on to talk about in a moment, but let's just say issuing a privacy notice, for example, that's the responsibility of the controller. They should have a checklist that says, here are the things we need to do as controller, and that is a legal obligation on the controller. So it's one of these strange things. It's always been part of European data protection law. I think it's something that those outside Europe scratch their head about and say, why make this distinction? But there it is. It's part of the law, and slightly different responsibilities depending on whether you are a controller or a processor. The important thing is, let's say you are an RMC and you have your corporate client. The critical thing is to agree with your client who is acting as controller. So there should never be any doubt about what your status is. And the reason for that is if there's any confusion, then that confusion applies to the individual who's meant to have absolute clarity about who is primarily responsible for my data. So that's when it really matters. The technicalities of, well, could I be a controller for this, or should I be a processor? As long as it's clear in your contract with your clients, with your suppliers, that's the critical part of it. Right, two aspects to looking at: is my business GDPR compliant? It's important to be clear, and the absolute starting point is always, what is the data, the personal data that flows in and out of my business? So firstly, you need to be able to have this overview. What are the different types of data you hold? And again, this may be as basic as contact details, or it may be quite sophisticated information that you hold on some individuals for particular services. Immigration services would be an example of that, where you obviously will hold far more information than somebody providing a more basic home search service. And then how do you use that data, you know, when it comes into your business? What are you doing with it? And you should be able to answer the question as to why you hold that data. You know, you should be clear that I need this data in order to provide these services. And if you find that you're collecting data that it's interesting for statistical purposes, but it isn't actually required, then you have to look again at whether you should be bringing in that data into your systems. And then there's a question of, are you absolutely clear on how you hold the data and where it's held? Because bear in mind, this is not just about IT systems. This is also data that you hold in filing cabinets on individuals. It's data that you may hold in a server in the country in which you operate, or it may be in the cloud, or it may be that you transfer that data to a partner company in a completely different country. So having this overview, and you can imagine a big sheet of paper here with lots of squiggles on it, showing data in, data out, what kind of categories it falls into. Somehow you need to have that big picture in order to be compliant. And then the second part of compliance is the documents and processes. Now, hopefully, for most of you watching this today, these will now be familiar names and designations of documents. When we started with the GDPR a few years ago, there was a lot of scampering around trying to work out, you know, what is a data privacy notice, or what kind of consent form do I need to use? These are absolutely all critical, and it's a matter of, sorry, I've just moved on. Yeah, it's a matter of making sure that you have appropriate documents and processes to cover all these aspects of the GDPR. So let me just highlight one or two of them. The data privacy notice, for example, is your way of communicating to an individual what you will do with their data, what their rights are, what they should do if they're unhappy about anything. So this is, you know, back to clarity and transparency. Consent forms, for example, I've touched on before. If you need an individual's consent, you have to design a form to make sure that they are freely giving that consent, they understand exactly what they're consenting to. It's obviously critical that you hold these records, because you may be audited by a client or by a data protection authority. Your policies showing your retention periods we've touched on, keeping records of your compliance. Who do you share data with? And if so, if you do share data across the supply chain, do you have contracts in place? Because it's essential under the GDPR, if you hold data, if you're processing data, and then you share that data, not only do you need the consent of the individual to their data being shared, but you need a contract in place that has to have certain requirements on that sub-processor that you're using, so that the GDPR rules apply to that sub-processor. And then there's a whole raft of stuff about transferring data outside the European Union. There are strict requirements about when you can transfer data and how you should do that. And I'll be touching on that in a little bit more detail in a moment. Now, just before I go, yeah, well, that's perfect interruption. I was just going to say, anything so far that you'd like me to say more about, Dom?
Well, there was a couple of things. I mean, first of all, just so that everybody listening knows, Gordon has written a brilliant guide to all of this, which is on the EuRA website under the Publications tab. So you can download that at any time, and it does cover everything that he's just talked about. Just remember that you need to be signed in as a EuRA member to be able to access that. But there was a couple of things that cropped up that we've talked about over the years, which always seem to, and I think you're probably coming on to it, but when you were talking about sharing and integrity and confidentiality, I remember when the very first meeting came up about this, one of our board members said, well, we're under an obligation from an RMC to keep offsite backups of all data so that we can recover, you know, as part of a business continuity plan. And of course, back in the day, we all used to use these, you know, big discs that we used to carry around and put in a safe. And he was saying, but actually, I would probably be in contravention of the rules, because during the time that I'm taking that from my office to the safe in my house, it's no longer secure. So it might not be seen as being, you know, confidential anymore. What happens with that? And also, how is that now impacted by, it's a separate question really, but how is that now impacted by cloud storage and where cloud storage servers are located?
Yeah, let me touch on the second point first. I mean, the GDPR is completely neutral on use of the cloud. So it's not saying either, oh, this is a really good thing or it's a negative thing. It's really just the same rules apply. Where is the cloud storage taking place? So if it's servers in the EU, that's obviously a bit simpler if in compliance terms. But I know that often data is held centrally. The cloud will be in the United States. So that just means that the rules on data transfers to the United States have to be complied with, which I will come on to talk about a little bit. So the cloud is not a problem. It's just, you know, where in practice is the data. In terms of, yeah, if you are looking at your policy on disaster recovery, the GDPR would say that is critically important, because personal data that you hold, what if my office goes up in flames? You should have a system for being able to recover that data. You clearly would want to anyway, but under the GDPR, that would be a responsibility too. Have you taken reasonable, proportionate steps to protect data? Now, it's certainly true to say that when you move data from one secure location and you have it in whatever, you know, as you say, it used to be in disk form, we had various methods of doing it. It may just be you've transferred it onto a laptop and you're taking it somewhere else. These are danger points which have to be recognized, and therefore you would probably have a policy which said, when data is held outside the office, here are the considerations to have. And, you know, it's as simple as to open a laptop, there has to be password protection, etc. So there's nothing the GDPR says that prevents you moving data in that way and taking sensible steps to have a backup facility. It would encourage it. It just would say, think about how you move the data for backup purposes, and is that a weakness in your overall protection? And if so, what should you do about it?
Yeah. And Eric, thank you very much for your question. Can a processor obtain consent from an individual, or can that only be obtained by the controller? We've used other legal bases for processing, but have debated the consent part as a processor.
Yeah, my understanding would be that the controller with the responsibility for to the individual for compliance has the primary responsibility here. So, and when, as a processor, you enter a contract with the controller, a clause in that contract would state that you cannot sub-process, you cannot bring in another processor without the consent of the controller. So you would be going back to them and saying that for this specific service in this specific country, we want to use such and such a supplier. Now, in terms of the individual's consent to that, I would be suggesting that the controller obtains that, but provided that consent is obtained, and this is where the GDPR as a set of principles can kind of clash with the practical day-to-day operations of a relocation business, for example, because we have these rather complicated supply chains. We want to be able to move things quickly to another country. It's in everyone's interest. Nobody's data is being put at risk. But if the rules are making it more complicated, I don't think an individual would thank me if I said, oh no, you can't consent to me. I have to go back up the chain and you'll hear in a few days from such and such employer. And nor would that employer be thanking me for doing that. So this is where I think you have to be pragmatic, provided what's happening is transparent and provided the consent is clear. It seems to me going direct to an individual through a processor must be okay, but if you're asking me in a technical sense, the idea is, yes, everything comes down from the controller.
That's brilliant. Thank you for that. And thanks for the question, Eric. Also, just going back to fairness and transparency, I wondered when I was listening to that, and it's something we've talked about, how far does that impact on T's and C's? I mean, I remember when GDPR came in, you helped us to restructure the terms and conditions on specific things like booking the conference, that you can't just go point 1, point 2, point 3, point 4, point 5, ad infinitum, tick at the bottom, and it's all signed off. It had to be more, I do agree to being filmed. I do agree to being photographed, tick, tick, rather than just, so again, for terms and conditions for a relocation provider, are we still having to be more cautious than, for example, every time I get an end user license agreement from Apple, it's 50 pages and I just tick one box?
Yeah, that's such a good example, Dom, because yeah, that was something that the GDPR changed. It did say it's not enough to have this long document and you're consenting at the end, whereas what the GDPR would say is, yeah, you have to be given the opportunity to consent to some things and say, no, I don't give my consent to that. So there is an obligation on an organization to, wherever it's possible, to break down what am I consenting to. And yeah, that really is such a good example of it. Now, often it will just be all or nothing. And again, if we look at the context of relocation, it would be impossible to deliver the service unless consent is given to several things, the collection of that data, the sharing of that data with your partner in another country, etc. It's all ingrained into the service. But the obligation is to step back and say, is it possible to split things up and seek separate consents? And if it is, then that's what you're meant to do.
Brilliant. Any questions? Again, just pop them in the chat box and we'll get round to them. Gordon, on you go.
Yeah, so this is looking at the language of the GDPR, and it was the sixth principle that I mentioned earlier about data integrity and confidentiality. And the GDPR talks about taking appropriate technical and organization measures, meaning by that the systems measures and people and organizational measures, the training you do, the guidelines you issue to individuals, as well as the purely technical systems you have in place. Now, the challenge, I suppose, for some companies is, well, what does that mean in practice? What should I be doing? Does that mean I need to encrypt all emails? Answer no, because what the GDPR is saying is it should be proportionate. And I mentioned here the first bullet point. Would a data loss be simply embarrassing, or would it be hugely damaging to individuals? If I run a tennis club, and instead of blind copying when I send out something to members, I send it, everyone can see all the email addresses and who all the members are. Well, I wouldn't look good, but it wouldn't be a serious data breach. Whereas if I run a medical facility and people are coming into my clinic, and I send something out that shows everyone who's attending that clinic, that would be obviously a serious failure. And therefore, I should have systems in place that provide a higher level of protection in that context than if I run a tennis club. And I've just mentioned here the kinds of things to think about, when passwords are required, when encryption. There may be situations where encryption is necessary. It may be because a particular client requires all reports to be encrypted. And again, not forgetting what goes on in your office away from the IT systems. Are filing cabinets locked? If indeed you still have filing cabinets. Are these filing cabinets behind you there, Dom? I'm not quite sure. But if you still do, if they contain personal data, they should be locked. Desks, you may have a clear desk policy. Are documents stored beside printers and copiers? Are documents stored for shredding that other people who would be unauthorized to see that data could have access to? Do you have an internal system for reporting breaches so that you can find out, where are the weaknesses in our system? What are the things that do go wrong from time to time, so that you can continue to improve the system? And one absolutely key aspect of that is staff training. So in other words, it's not enough just to have guidelines and issue policies. You have to be confident that your staff actually understand these policies and comply with them on a day-to-day basis. And what we touched on earlier, Dom, protecting data outside the office, absolutely critical, because so many fines that are issued relate to people leaving laptops around, leaving a briefcase on a train. And I've heard it, sitting behind a couple of lawyers on a train, and they think the train noise means that I can't hear what they're talking about. They may be talking about a court case. It's crazy that, even people who are security conscious, sitting on a plane or sitting in a train with a friend, can give away information. So very, very important to think about these things that are not immediately associated with IT.
And it's ridiculously easy to do. I mean, I've had this conversation with a few people, but the first time I traveled or got on a plane, sort of post-COVID, end of last year, I left my telephone. I'm just not used to traveling anymore. So I left my telephone in the airport. And I didn't really think, I mean, obviously, as soon as I got to the other end, I had my laptop. It's an Apple machine. You're able to set it back to factory settings remotely. So I was able to do that. But if you can't do that and you forget you've got the Dropbox app, you've got access to the cloud on a mobile device, these, it's stuff that you really do have to think about.
Yeah, and that's it. It is just thinking about all the potential leakages that can take place, and what would happen if this, and how would we be protected? But the word proportionate is really important, because you can be so ultra secure that running your business becomes a nightmare. So, there's, and unfortunately, I think for most relocation businesses, the nature of the data we hold, while it's personal data, it's not usually highly sensitive personal data. So it's a little bit easier. I just want, this may tie in with the question we had earlier, this question of when you have a controller, a processor, and you may then have a sub-processor. These are the things that need to go into a contract. So as soon as you are processing data, you should have a contract with the controller, and the GDPR requires certain things to go into that contract, such as you can only act on their written instructions. You have to ensure that your own employees have a duty of confidence, of confidentiality. And the one about only use a sub-processor with the controller's consent, and you need a written contract with that sub-processor. Submission to audits is another standard one worth mentioning. And while the primary obligations, if you are, let's say, operating in Germany, the Data Protection Authority will primarily go after the controller if there's been a serious breach of the rules, but they can also go after the processor as well. And that was a change in the law. At one time, it was just controllers, but processors are now subject to fines for breaches as well. And I always like to just add in this slide to remind us that it's not just about relocating employees and the services we're delivering to our clients. Our own employees are covered by the GDPR. And so we will certainly hold data on our employees, and I've listed the kinds of things we would typically have. At the very least, we'll have contact information. There may be a CV, there'll be an employment contract, an employment record, performance reviews, complaints, bank details for paying salaries, and email correspondence with that employee. So there's actually a lot of data, and that data needs a lawful basis, just as we talked about earlier, which would normally be under your employment contract, and under the law, it's necessary for an employer to hold that kind of data on an individual. And it's the same questions. Is the data held securely? Is it accurate? Is it still necessary to hold that data? Can that be deleted? And the employee is entitled to receive a privacy notice. In other words, they are entitled to a statement of the basis on which you hold their data and what they should do if they're unhappy about anything. So yeah, let's not forget about our own employees in all of this. I'll touch briefly on international data transfers. If there are two big issues that tend to come to me most commonly, one we've touched on before was, am I a controller or a processor in this situation? And the other is, I'm making increasing numbers of data transfers outside Europe. What do I need to do? What documentation is required? This is an issue because Article 44 of the GDPR prohibits data transfers to non-EEA countries. EEA, just to be clear, is European Union countries plus Iceland, Liechtenstein, and Norway. But there are exemptions, and if a country has been granted an adequacy decision by the EU Commission, then you can transfer to that country just as if it were part of the EEA. And I've listed there the countries that are currently covered. And when you look at it, it just looks like a pretty random list of countries, but it's because they happen to have laws in place that the European Commission have decided are broadly similar to the level of protection that would exist in the EU. And so we have Argentina, Canada, New Zealand, etc. The UK is now regarded as adequate, though it's interesting that that adequacy decision is subject to a 4-year review. So that possibly says something about the state of the relationship between the EU and the UK when this deal was done, because all the other adequacy decisions are unlimited. But clearly the EU didn't trust the UK to continue to have very strict data privacy laws, and so they put this time limit on it. And I've mentioned here just some of the countries where, you know, many relocation businesses will transfer data that are not regarded as adequate. The most notable being United States, but also Australia, India, China. Now, you can rely on the explicit consent of the individual. So if you've got a one-off data transfer, that's fine to rely on consent. But the rule is that if you're doing that on a volume basis, then you shouldn't rely on consent. It's for one-offs rather than volumes. And so we fall back in the final category, and these are called binding corporate rules. If you move data within your organization, so if you're a group of businesses and you're in Switzerland, the United States, Argentina, China, you can create these binding corporate rules and you register them with the EU. There's a lot of hassle involved, I should say, but it's one way of dealing with internal data transfers. The most common, though, is called standard contractual clauses. And these are used for transfers, you know, particularly to the United States at the moment. And this is a time where I need to introduce a figure called Max Schrams. Firstly, I should explain that that is not actually a photograph of Max Schrams. That is a photograph of Miss Murphy, my dog. And the reason Miss Murphy is replacing Max Schrams is that I couldn't find this morning a photograph of Max that was not subject to copyright. So I would have needed to pay for a license. That wouldn't have been a problem for the purposes of this presentation, but because Dom will want to, he's recording this and it will be then on the website and available to all members, we are uncomfortable about getting claims for breach of copyright. And Dom and I may talk about this a little bit later, but it's such a good illustration of nothing to do with GDPR, but just if you're putting photographs on your website in any shape or form, make sure that you're licensed to do so, or that that particular photograph is not subject to copyright. So thank you to Ms. Murphy for standing in. Right, what about Max Schrams? He is an Austrian lawyer who worked for Facebook in Ireland and was uncomfortable with the idea that Facebook was transferring all this data from Europe, from their Irish operation to the United States. And he felt there was all kinds of data there that wasn't being properly managed. And he went to court in 2015 and won the case. And at that time, we moved data between Europe and the United States under something called Safe Harbor. And Safe Harbor was declared invalid as a result of the Max Schrams case. It led to the EU-US Privacy Shield in 2016, which was a more robust version of Safe Harbor. It had more protection built in for personal data. But Max was not finished yet. And in 2020, he won another battle in the European Court of Justice and actually had the Privacy Shield declared invalid. And his argument was that in the United States, the law enforcement and security agencies have far greater rights to access personal data than would exist in Europe. And the court agreed, and they said, yeah, we require the US government and the EU Commission to go away, think again about this, because we're not happy with the protection given to this data. And it's called the Schrams 2 case. Now, the one good thing from the point of view of businesses who do move data between Europe and the United States is that the court said that while this the Privacy Shield was invalid, companies could continue to use standard contractual clauses and move data from Europe to the US on that basis. So provided you got the documentation correct, and they did emphasize this is not a box ticking exercise. You need to look at what's being moved, and you need to have a very specific contract in place for this. But basically, it meant that we could continue to move data to the United States using these clauses. How do they work? Well, it's a standard document. There are 4 versions of it because it can be controller to processor, controller to controller, processor to processor, or processor to controller. So whatever variation it is, there's a model form of contract to use. Quite a lengthy document, 18 standard clauses, and then 5 annexes to be completed with all the details of the data transfers and what the security measures are being put in place at the US end to protect the data. So, you know, it's pretty hefty form filling that's required. But basically it's saying, and of course I'm using the example of the United States, but it could be Australia, it could be India, it could be China. If you're sending this data off, it's really imposing GDPR type obligations on the importer of that data in India, China, etc. So the idea is it has equivalent protection just as if it remained in the EU. In terms of what's happening next, I think we're finding that more countries are beginning to adopt GDPR type laws. I think it's almost as if the EU has now set the standard, and more countries will follow, more parts of the world seem likely to follow. And that in turn means that there'll be more adequacy decisions. So that relatively short list of countries that exists just now that are regarded as adequate for data transfers will I'm sure increase. And the very good news just a few weeks ago is that the US government and the EU Commission have agreed on a new form of data transfer framework, which would mean you wouldn't need to use standard contractual clauses. But that has just been agreed at high level. It was announced by Joe Biden and the EU president, and the details of it we haven't seen yet, but I presume it will just be an even more robust version of Safe Harbor and the Privacy Shield. Couple of negatives. Up until now, throughout Europe, the data protection authorities have seen themselves as advisors. They will help companies comply. They will give advice. Their websites are full of useful, practical advice. But there have been some huge fines for large companies, particularly in the financial sector or in the travel sector. Companies who've been careless with data have received huge fines. And we just have to be careful. The data protection authorities may shift from this kind of light touch approach to one of stronger enforcement, with the incentive, of course, of they raise funding by doing that. And final word to Max Schrems, because he's already said that whatever this new EU-US framework is, he'll be back in court. There will be a Schrems 3. So let's just hope that this new framework agreement can withstand the next court action from Max. But as I say, it's premature at the moment. It's probably going to be a few months before we see anything. And if I could just leave you with, where to get further information, the European Data Protection Board website is very useful, as is the UK equivalent, the ICO website. And they really do try to give practical advice and lots of Q&A stuff. So they're both good websites. We've already mentioned the EuRA guide to the GDPR, the ultimate guide for relocation businesses, which is available through the website. And if you decided you did want to do some internal training for your own people, or for your own people and your supply chain, then please let Dom or myself know, and we can set up a training session kind of tailored around your requirements. We're always happy to do that. So, Dom, I have attempted to cover the GDPR in 50 minutes instead of 30 minutes. So apologies for running late, but we got there.
It's big stuff, and it still continues to be. I think what's so interesting about, having run these over the years, I mean, I remember when we first sat in a board meeting actually in Dubrovnik way before the conference, and you outlined this to the board, this was coming. And I remember a couple of board members going, well, we're not going to be able to continue doing what we do. I mean, the fear that this placed on people, and I remember we were invited to the Relocation Directors Council in the US to talk to their members about the impact of GDPR. And companies in the States had spent tens, if not hundreds of thousands of dollars preparing themselves for this because of the fear of litigation that would come after it. What I thought was very interesting was you said the light touch that's been, up till now, with the exception of those notable fines for the big travel companies. And is it still the case that this is primarily aimed at Google, Netflix, Facebook? It's aimed at the FANGs. It's aimed at big, like pharmaceutical companies or medical, like the NHS in the UK, or holding really specifically very sensitive individual data.
That has certainly been the priority. And of course, if you're cynical about it, you would say, well, these are also the cases where there will be maximum publicity for the Data Protection Authority, and it will be money raising as an exercise because the fines are so huge potentially. I just felt it worth saying that they're bound to spread. It's a bit like when, I remember, the competition law rules that seemed only for huge organizations who were, setting up agreements that were against the public interest and all on a big scale. And then we found that, no, it came down to smaller businesses as well. And if you agreed on prices with a competitor, no matter how small you are, you would receive a very substantial fine. So I think there's a case of saying they have had this light touch. They've been happy for organizations to let things bed in and work out how to comply. But I think for any blatant breaches, I think they will start to come after smaller businesses as well, particularly when there is a complaint. But you could have a whistleblower, or somebody, a dissatisfied employee leaves the company and decides to get revenge. We will see these definitely happening. Yeah.
And I mean, tell me, from the point of view of our members, what's been the most, I mean, over the 3-4 years that this has been in place, and you've spoken to so many members, what have been the most problematic areas of this, particularly for relocation providers?
Yeah, the most questions that have come in have been in these two categories. It will be, we're entering a contract with a client, and the client is saying that they want us to be either to be a controller, and we don't think that's correct, or they want us to be a processor, but would we issue the documentation that the controller would we issue the privacy notice, etc. So I think confusion around the controller processor has definitely been one area, and that's why often I'll say, look, don't worry too much about being absolutely technically correct about this, provided you and your client agree we are controller, we are processor. But I just say there have been some pretty mixed up cases I've heard about where it's like, we don't want you to be controller as an RMC, but we do want you to issue, be responsible for all the admin, and that gets a bit messy. But it's not the worst breach of GDPR. And sadly, the other one is the whole Max Schrams stuff. Just as soon as a company gets organized under Safe Harbor, boom, it goes. You get organized under the Privacy Shield, bang, it goes. And huge volumes, including in our industry alone, moves between Europe and the United States. It's the most, it's because there are so many head offices in the United States, inevitably data is passing all the time. And that's a real hassle. And it's not a problem understanding it, but it is a problem actually dealing with the sheer admin burden of making sure we're compliant.
I mean, certainly the people, we were all just left in limbo. Was it in 2020 when that came in, and suddenly there was nothing anymore, and it was like, well, what do we do?
Yeah, that's right. And we were all having to dig out these old standard contractual clauses. And, so yeah, it's not good. I'm sure a lot of people in the business world really dislike Max Schrems. His argument would be, well, I'm a privacy activist and I'm looking after the rights of individuals, but some of it now is based on very narrow distinctions between what a law enforcement agency can do in the United States and what they can do in the UK or what they can do in Germany. And, it's, you're blocking huge transfers of data on the basis of these fine distinctions. But anyway, that's what the European Court of Justice is there for. And hopefully we will have this new framework shortly.
And just going back to the issue of copyright, this has bitten us twice in the last year. So I had an email come through, and it was from a company saying, you have used this image and you now need to pay 500 euros. And so I went to Gordon. I was like, is this for real? And you very kindly looked it up, and it is. I mean, it's almost a scam. It's this close to being a scam, but it isn't. This company trawls the internet looking for images. So the image in question, right, was on our website, buried on page 42 of a 3-year-old edition of the European. You've really got to look very carefully. You have to click on it, go to issue, and there's 1,000 images in an edition of the European. The one's going out tomorrow. This happened to be a photograph of the Holocaust Museum in Warsaw, which we had in the European as something that was fascinating and relevant to experience while at our conference. And I'd actually taken it from the website of the Warsaw Convention Bureau, who had told us that we could use the imagery, but we didn't own it. And so we paid a 500 euro fine for using that image, which was so, anyway, subsequent to that, you'll see there are no Europeans going back anytime now. They've all been deleted. But it really is, now that means that, anything that you use, if you're using an image on a piece of publicity material, on your website, on a PowerPoint, make sure you own it. If it's going to be anywhere out there in the public domain, make sure you have the copyright rights to it. And so, I mean, the good thing is, we were talking about this as well, Gordon, there are now so many free access image libraries that this business is slowly coming to an end. I mean, if you use something like unsplash.com, UNSPLASH, unsplash.com, completely free sharing library of amazing photography from all over the world. We use it all the time. But I mean, it is really, they're really, they're making money out of it.
Absolutely, that's why you're right to describe it as a scam, but it's a legal scam, unfortunately. So, and they obviously have technology that can scan huge volumes of photographs, other images, and pick out anything that's subject to copyright. So yeah, it's a really good health warning, and probably in the past I wouldn't have been too worried about putting on a picture of Max Schrams. But just some recent things that have been going on, there's more publicity being given to this issue. So yeah, Dom and I have been talking about it a lot, and it would have been very embarrassing if I had given you an image and it had gone on the website and EuRA were fined €500.
That would not be good.
Yeah, that was
our legal strategic consultant. Yeah, that's great. But yeah, it's just really worth bearing in mind. And from that point of view, there are all those free to there's all the photo search and Shutterstock, and some of them can get expensive. But just make sure you're using images that you own the copyright for. Gordon, thank you so much as always. A terrific session. Session number 2 will be on Monday, the 16th of May. Same time, 1600 Central European time. You'll be receiving emails and bulletins about that. But if you do want to book it, just go straight ahead to the website. It's already live and ready for booking. So we look forward to seeing you then. And Gordon, what are you covering in session number 2?
Right, the core subject will be contracts, the contracts that are entered into with corporate clients, between RMCs and suppliers, between suppliers and their sub-suppliers in different countries. What are the kind of issues that arise from that? What, if you don't have your own in-house legal team, as obviously most EuRA members will not, what are the things you should be looking out for if you're reviewing your own contracts? So we'll do that, and we'll also pick up on the kinds of questions that have come in the last 6 months, covering a whole range of things. We just happened to pick up on copyright today, but there's a wide range of questions covering everything from anti-money laundering to VAT to whatever. So I guess I should also remind everyone that before Seville, remember, it's fine under competition law to talk about any subject you want to, but do not agree on a collective action. So that's the important distinction. Talk about anything, complain about anything, but don't say that, all together as a group, we're now going to do this, or we're going to charge this, or we're going to put this new contract in collectively. That's when it breaches competition law.
Absolutely. I mean, it's interesting you say that. By the way, thank you to Kelly and Helen for your thanks. So lots of thanks coming through in the chat. But no, you're absolutely right, Gordon. And certainly that's one of the conversations that we've had over the years and years in EuRA has been, can you not advise on pricing? As an organization, can you not advise on pricing? No, absolutely can't, because then you're in danger of forming a cartel or encouraging your members to form a cartel. And that then becomes anti-competitive. And also, just a quick plug, Gordon's put together a brilliant anti-money laundering module in the Academy that's free for you to access. I think it's still free to certify. I'm not entirely sure. You may have to pay for the quiz now, but it's certainly free to access if you want anything to do with anti-money laundering. It's actually really fascinating. I learned so much from that. I've never really understood the dynamics of money laundering, but you really put it into great perspective. I now understand Breaking Bad, which I didn't for a very long time. So thank you for that. Listen, everybody, thank you so much for joining. As I say, this is going to be on YouTube. I'll send you the link hopefully tomorrow. So if you want to go back on it, you want to share it, please do. It's in the public domain. And Gordon, we'll meet again on the 16th of May.
Excellent.
Brilliant.
Thanks very much.
Thank you, everybody, for attending. See you soon.
Bye.
Oh, Gordon, I need to reclaim the host, or I can't close it. There we go, done that. Right, bye, everybody.